Amber, I have 12 o'clock. Are we about ready to start?
We're good to go, Mr. President.
All right. Well, welcome to this week's edition of Shop Talk. And the weather is beautiful in southern Minnesota. Hopefully it is where you're at. Harvest has been going very well. I think here at the PAPS, we're on day 14 of harvest, day 5 of corn. So things are going good. Weather's been cooperating, and it's been a good time. So we're actually combining corn as we're doing Shop Talk. Hopefully nobody's in the shop fixing today, and you're all busy doing that. I think probably the most important thing of the day as we think about the longer harvest season, just again asking everybody to be very careful out there, whether you're on the farm or the ranch, around the animals, or even on the roadways. Keep an eye out for each other, take your time. And if you're not farming and watching this today or watching this, keep an eye on those rural roadways too. Farm equipment, trucks, combines, a lot bigger, slower, and everything else. Kind of the same drill as normal. We'll have our special guest, Travis from the American Farm Bureau. We'll have a chance to interact. So either use the chat feature, the Q&A feature on your iPhone or whatever you're using, or if you're on a cell phone, that's great. Just got to remember to hit *9 before you can queue up your question. So *9 if you're on a cell phone. With that, I'm going to, last week we had conversations with a banker, and we went right to conversations with a lawyer. I think that'll be a great opportunity. And I always get worried about introducing lawyers to remember what in their bio to include and how not to offend lawyers. So Travis, with your permission, I'm going to ask you to introduce yourself so I don't screw it up. So Travis, welcome to this week's Minnesota Farm Bureau Shop Talk from the Combine. Travis, please.
Great. Thank you, President Pap. I greatly appreciate the opportunity to come on and speak with you all. My name is Travis Cushman. I'm the Senior Counsel for Public Policy at the American Farm Bureau Federation. And in that role, I oversee our nationwide litigation efforts to help shape the laws of agriculture and as helpful as possible for farmers and ranchers across the country. And I also work with our public policy folks to help them on the legal issues they face and the regulatory rulemakings. I recognize that not everybody will be able to see this presentation. In fact, it sounds like most people might be listening in. I'm going to throw on some slides while I'm talking. They're not necessary at all to what I'm saying. They're just helpful visual aids for folks that like to look along and see things as well while I'm talking, in case that folks start getting lost a little bit. So I hope you leave this presentation with a greater appreciation for the courts, perhaps pick up some of my frustrations with how courts often go, and develop a better understanding of why the courts and not Congress so often seem to make important laws that affects farmers and ranchers. The Office of General Counsel is actually where the legal advocacy program lies. We're not within public policy. We're in the OGC, Office of General Counsel, which means that we report to the General Counsel, Ellen Steen. And to give a brief overview of this program, we're going to talk about the litigation, how the program works with public policy, what we do to help build relationships amongst the industry, and how we work with state farm bureaus to ensure that everyone is on the same page with the various threats going on. And so with that, I'd like to start with a brief primer of a civics lesson of the difference between the different branches of government. So you have the executive branch and the legislative branches, right? The president and Congress, which everyone's mostly familiar with when we talk about the laws. But the judicial branch is also very important. It's often forgot about, and I think much of the advocacy efforts in Farm Bureau focuses on those first two branches of government, but we can't forget about the third branch, the judicial branch, because it can force the hand of the other two branches, and it can also undo the things that those other branches accomplish. So why and how does the judicial branch, the courts, make law? A jaded view might be that courts are where you get things done. Congress is viewed as often increasingly dysfunctional, And even to the extent that it's not dysfunctional, you can't always get what you want in Congress. So the courts are often the solution for that. But we can't also forget that that's what courts are for, right? They're supposed to step in and block when an agency makes a rule that violates Congress's statute, or alternatively, when a statute is inconsistent with the Constitution. That's what that's what courts are for, is to correct those things. And we can't also forget that the Congress and the executive branch are not perfect. They are generally run by politicians, and they will sometimes do things that runs afoul of the Constitution or the statutes that are in place. And often being politicians, statutes are sometimes ill-crafted, and courts need to step in and figure out what Congress meant when they said the words they said. And to give a brief overview of what courts look like, both state and federal systems more or less mirror each other. You have a trial court, or what in the federal court is called the district court, and that's where things start, where the facts are primarily hashed out and a ruling is made based on what facts are determined according to what the law is. After that, you have an appellate court and a Supreme Court, which will review those facts in the context of the law and make sure the law is accurate. At the Court of Appellate level, you have several different circuits across the country, and Minnesota is in the 8th Circuit. We often see a lot of fights happening in the 9th Circuit and the 4th Circuit, which have over time become more favorable to certain environmental type groups. But the 8th Circuit is where Minnesota is, and so whenever you hear the 8th Circuit, you know that's the Court of Appeals that covers your jurisdiction. And so when AFBF looks at jumping in a case, what we look for is to make sure that the case will have a broad national impact on agriculture. That'll be impacting farmers at least regionally. So we only get involved at the federal level, not the state level, because again, the state level will only be making law for farmers in those states. And we're less concerned with the factual issues and the legal implications, right? Because at the factual level, at the trial court, facts change from case to case. We want to make sure that the law is being made best for farmers and ranchers. So we primarily get involved at the Court of Appeals level or the Supreme Court level. At any given time, we have between 20 and 25 cases that we're overseeing and involved with. And our involvement changes from being involved as a party to the case to filing what are called amicus briefs. An amicus brief is Latin for friend of the court, amicus curiae. And what that means is we submit a brief to the court saying, based on our own unique expertise in this area, here is some unique viewpoints on this issue that might help color or help you better understand what the law should be here. So we are involved as a party or an amicus, and our docket of cases is quite diverse. To throw some statutes at you that we're often involved with, we have the Endangered Species Act, Clean Water Act, FIFRA, the NEPA, National Environmental Policy Act, and we're involved with a range of issues, land use issues such as public lands, property rights, water issues, access to pesticides, herbicides, a lot of constitutional cases, and regulatory reform. So it's a broad swath of cases, and again, our focus is to help shape the laws in ways that will impact farmers and ranchers at a fairly large scale, not just necessarily at the state level. And I mentioned that we also work quite a bit with the public policy folks. And a good example of that, I think, is in June when the 9th Circuit Court of Appeals vacated the registrations for 3 Dicamba products. Dicamba is an herbicide. There is some controversy to it. I know it often will kind of pit farmers against one another. But what happened in this case is in the middle of the growing season, the 9th Circuit said that all Dicamba products are illegal to use. And so I think we can all agree on this, farmers that have invested substantial sums of money in these systems should not be forced mid-season to lose that and abandon it and figure out how to try to attempt to recover at that point. So on June 3rd, the 9th Circuit vacated the registrations for these 3 Dicamba products. 2 days later, working with public policy folks, we sent a letter to EPA asking for EPA to allow farmers that had already purchased Dicamba to continue using their existing stocks. Existing stocks is what we're seeking to be able to use. A few days later, on June 8th, EPA issued a cancellation order which allowed Dicamba purchased after June 3rd to be used until July 31st. A couple days later, the ENGOs that had brought the suit sought to vacate that cancellation order from EPA and told EPA in contempt of court. AFBF got together with a coalition of national grower groups and trade associations and asked the court to reject that motion. And we explained that doing so would cause farmers and ranchers immense harm. And it explained the necessity for farmers to be able to rely on EPA's registration process when making planning decisions. So what we really want to do is preserve the integrity of this process so that when a farmer knows something's registered, they can at least have some assurance that they can buy the product and be able to use it when they need to during the growing season. So a few days after we submitted our brief, the NGOs almost immediately asked the court to refuse our brief. They did not want the Ninth Circuit to hear AFBF's brief on this issue. Fortunately, that same day, the Ninth Circuit rejected that request, allowed our brief in, and denied the ENGO's emergency motion to revoke the cancellation order, allowing the cancellation order in the existing stocks order to stay in place. So that's kind of an example of how our work, the legal advocacy program, works hand in hand with our public policy shop. And you can kind of similarly see how often you'll have public policy folks who work on a regulation, gets through, gets challenged, that we want to challenge it or we want to defend it once it's gone through. And then that's when the legal advocacy program will kind of take over at the judicial court stage to help defend or oppose the regulation. I mentioned another thing that the program does quite a bit is we work with other groups to create coalitions. This is very valuable in the courts to bring a diversity of viewpoints to an issue, to bring other industry recognition or name recognition from other groups. And of course, it's always helpful to have other folks helping pay the bill with you. And finally, the AFBF program for legal advocacy also works a lot with our state farm bureaus and facilitating collaboration, making sure that we're all aware of various threats facing agriculture. And so I thought it'd be kind of fun to talk about a few cases that we're involved with to give you an example of what kind of work we do. So I'm gonna talk about a case we have, two cases involving livestock, California Proposition 12 and the North Carolina nuisance suits. Then I would like to talk about the Clean Water Act, WOTUS cases we have. If we have time, I'd like to also touch upon at least one recent decision we had at the Supreme Court, which was favorable for agriculture. So the first case I wanted to bring up involves when states are trying to regulate commerce outside of their state, California Proposition 12. And the issue here is, can an individual state leverage their market power to dictate farming practices in other states? So can California tell farmers in Minnesota how they're going to farm on their land? And this is part of what I would say worrying trend we're seeing across various industries of states leveraging their market power or location to try to dictate commerce in other states. For example, there have been several cases on the West Coast where Washington and California have attempted to block coal from going through or being exported in their states under the idea that it will contribute to climate change and global warming. But the concern is that when you have states prohibiting commerce of certain disfavored products, what happens when they decide that an agricultural product is disfavored because of whatever type of growing practice that state does not like? So here, in the case of Prop 12, this is a ballot initiative, and it creates minimum requirements for housing livestock. HSUS, Humane Society of the United States, is the primary author of this statute. And I'm going to put on the screen right now more specifics of what it does, but as to pork, what it does is it requires any pork that is sold in the state to come from a sow that was never in a gestation gestation stall, or breeding stall. The problem is that over 95 to 99% of pork does not meet these standards. The law specifically requires 24 square feet of floor space per sow, and that is just not how things are done. So it's wildly problematic for farms across the country that will have to comply because the way pork is sold is it goes to a packer and it can go into any state. Pork is generally not raised in one state for the purpose of being consumed in another state. That's just not the way the efficient markets have created things. Not to mention, anecdotally, we have seen that an 8 to 10% drop in farrowing rates when you try to implement some of these practices that Prop 12 would require. So what this essentially does is it would force a couple poor options on farmers. If a packer allows them to not comply, you're losing 12% in the market, which is the California market share. Alternatively, if you're being required to meet these requirements, you're gonna have to retrofit your facilities, which would require either you reducing your yield by putting less sows in a given area to get that 24 square feet, or alternatively, increasing the size of the operation by quite a bit. Looking into what this means for the future as well, Massachusetts has already passed a similar law. HSUS plans to get similar measures passed in other states. And this creates this patchwork of regulations that makes it very difficult to do business. And again, as I said, virtually no current pork production meets these standards, and it'd be wildly expensive for an individual outfit to make themselves compliant with Prop 12. So AFBF and National Pork Producers Council, we've gotten together and we have sued California for Prop 12, seeking to overturn it. Our legal claim is that it violates the US Constitution Commerce Clause provision. And to get a little bit of a legalese on you all, we allege that it has an extraterritorial reach and that it's regulating commerce in other states, and then imposes harms out of state that vastly outweigh any benefits to California. We are currently in the Ninth Circuit in our case. We started the district court stage. Now we're in the Ninth Circuit. The district court initially dismissed our case. Now we're appealing the Ninth Circuit. And we filed our briefs a couple of weeks ago. And significantly, we received the support of a bipartisan coalition of 20 states, 5 industry groups, and the United States of America, the DOJ, all filed amicus briefs in support of our case, arguing that our case should proceed. And that California Prop 12 does pose significant challenges to commerce in the United States that go beyond agriculture, obviously, into other types of issues. So that's an example of a case where we are a party to the case, right? We're the one that's actually suing. The next case I wanted to talk about is one where we file an amicus brief. We're not an actual party, we file a friend of the court brief. And that is the nuisance suits that are going on in North Carolina. And the issue here is somewhat, I think, as folks see it, is modern agriculture a nuisance? To give you some background in this case, in 2014, there were 26 lawsuits that were filed on behalf of 541 plaintiffs against Murphy Brown, which is a subsidiary of Smithfield Foods. The lawsuits name only Murphy Brown. And the claim is that the farms amount to a nuisance, these 89 swine farms in North Carolina, mostly eastern North Carolina, that are mostly run by contract growers. A nuisance, that means it's an unreasonable interference with the use and enjoyment of private property. And say that again, a nuisance is the unreasonable interference with the use and enjoyment of private property. In law, we have all these kind of odd phrases that we use and over and over again, and we generally use those exact words to describe something. So it's sometimes worth repeating how those words are phrased. But essentially what that means is that the odors, flies, truck noises coming from these contract growers were unreasonably interfering with the use and enjoyment of the plaintiff's property. Often we have what are called right to farm laws, which generally protect farmers from nuisance suits for standard practices. In this case, the judge ruled that the right to farm law in North Carolina did not apply. And the results were some pretty astonishing verdicts. In 4 of the cases, the damages have ranged from, in the smallest case, it's $100,000, but we have one case where it's $25 million, $50 million, and there's another case where the damages were $773 million, almost $500 million in damages, which is obviously a significant amount of money for any operation, no matter the size, to face. So one of those cases has been appealed to the Ninth Circuit, and everything else has been more or less put on hold while it goes to the Ninth Circuit to look at the law on this. And AFBF, and again, National Pork Producers Council, along with North Carolina pork producers, the North Carolina Farm Bureau, got together and we filed this amicus brief. And what we argue is that normal farming practices, practices that are in compliance with applicable regulations, they should not be subject to punitive damages. If you're doing something that is considered normal, punitive damages should never be on the table. So that's more or less what we focused on in our brief, and we are still waiting on a decision in that case. Next, I wanted to talk about waters of the United States and our advocacy efforts there. And to give you some background, the Clean Water Act was enacted in 1972. And the Clean Water Act prohibits a discharge of pollutants from a point source into navigable waters without a permit. The problem is the act defines navigable waters as waters of the United States, but it does not explain what waters of the United States means. So what this essentially means is that any pollutant, including dirt, that goes into a navigable water requires a permit. Permits are incredibly expensive, averaging $250,000, take significant time, averaging 9 months to get, and it's just not really practical for a farmer anytime dirt passes over an area that becomes a WOTUS, War of the United States, to get a permit. So this battle has been raging for 50 years now because, remember earlier I mentioned that Congress isn't always very exact to their phrasing. They weren't very exact here. It's can be argued to be ambiguous what this means, and folks have fought what is the proper scope of the water of the United States. So in 2015, the EPA came out with a rule that we viewed as a massive land grab. It broadly defines and vaguely defines the scope of a WOTUS for the purposes of federal jurisdiction under the Clean Water Act. And in our view, essentially what it did is it took a farm and you have what you consider a dry land feature that occasionally gets wet, and that would be deemed a WOTUS, which means you can't do anything with it. So again, it was a massive land grab, and AFBF put together a large coalition of 14 groups and challenged this rule. The coalition litigated extensively, and it resulted in the rule being blocked in 27.5 states. I have a map up on the screen that shows the various states that it was blocked in. Unfortunately, Minnesota was not one of those, although I understand that your water law, your state water laws in Minnesota are already a bit more strict than Clean Water Acts. That might not necessarily have had as large of an impact on you all. But I know it still does have a significant amount of impact, and you all would certainly prefer not to have it in place. So that was in the 2015 rule. We have since, the current administration repealed the 2015 rule, called the repeal rule, and they've replaced it. And both of those rules have been challenged. And AFBF has again put together a coalition to defend that rule. The replacement rule is more so now where the litigation is really getting heated up. There are at least 13 cases that I can think of on challenging the replacement rule known as the Navigable Waters Protection Rule. We're involved in about 4 of those cases in California, Colorado, South Carolina, and DC. And we've had pretty significant win in California. The plaintiffs were seeking to stop the rule nationwide. The judge declined that request. A court in Colorado did grant it, but only in Colorado. So the replacement rule has not gone into effect in Colorado. Since I have a couple more minutes, I just wanted to briefly touch upon a pretty big win we had in the last Supreme Court term. And this is kind of an interesting case because it doesn't involve agriculture directly. And it was also a case in which we filed an amicus brief, this friend the court brief. So we're not a party to the case, but we let the court know our opinion. So this case involves what is called agency deference. And it means when an agency drafts an ambiguous rule that's kind of hard to read and it's not very clear, should that agency be given deference when there is a dispute over what is said here? And the underlying case was about a veteran who's denied benefits, from a Vietnam War vet. So again, nothing to do with agriculture directly, but how the courts defer to an agency's ambiguous regulation is very important to agriculture. One problem with it is it encourages an agency to issue a vague regulation that can later reinterpret, to have the agency sees fit. So AFBF got together with some other industry groups, and an example of how it can affect agriculture that we gave the court is a Seventh Circuit case where FSA terminated a CRP contract that a farmer had for decades with USDA after it reinterpreted its own definition of mixed hardwoods without giving any kind of notice and comment or advance notice to farmer. And the reason I like this case a lot is because, so during oral arguments, the government was trying to argue that agency deference helps regulated communities, that everybody that's regulated likes agency deference and makes the world a better place, to which Justice Gorsuch, Supreme Court Justice, interrupted the government and chastised them and said, I don't like it when the government tries to tell us what regulated communities want. In fact, here, the Farm Bureau submitted a brief and they told us that they don't agree with you here. So the Farm Bureau certainly does not agree with your viewpoint on this. And the court ended up significantly rolling back agency deference and giving us better protections moving forward. So it was a pretty cool example of how, even though we weren't in the case ourselves, the Supreme Court read our brief. They used our brief during oral arguments to make a really important point about what's important to farmers and ranchers. I think that's about all the time I have to go over cases. I think that was quite a bit of what we have going on right now. With that, I'm happy to turn things over or take any questions you all have.
Well, thank you, Travis. Appreciate that. In Farm Bureau, when we think about Farm Bureau, a lot of times we think about policy, and we kind of divide policy up into the three buckets: policy development through our resolutions process, and at the different levels, policy implementation, getting it done in the state legislature or Congress or our local governments, and then that political action. But really, after listening to this, that policy implementation, we need to really divide that in half or divide it somehow. We've got policy implementing through Congress, rulemaking and everything else through administration. But do we make some policy or adjust policy through the judicial? How do we move that? How do we talk more about the judicial system as it deals with our policy? I think a lot of our members, you mentioned the amount of court cases we're in, at any one time at American Farm Bureau. I think a lot of our members don't understand how much involvement we have in the legal. Could you just talk a little bit about more how policy is either being implemented or changed through the judicial process?
That's a great point. The judicial process, it's where folks go when they're unhappy with what we get or what we lose, through statutes or for agency regulations. And it's anything that's a significant accomplishment for somebody, it's going to inevitably be challenged by somebody else. And so the work doesn't stop once you finish with a rule or a statute. It's going to end up in the courts. And so you have to think anytime you're working on this major initiative, it's going to end up being in the judicial branch at some point. And it's not just one case. It's often, if it's a big issue, it's going to be challenged across the country. For instance, in the 2015 rule challenges to WOTUS, there is probably 10 or 15 cases across the country on that. And all challenging the same rules, tons and tons of cases. And any one of them can go a different way. Similar right now with the Navigable Waters Protection Rule, there are at least 13 cases I'm aware of challenging that. And any one of those courts might try to stop the rule nationwide. So, it's incredibly important. It requires a lot of attention and resources to be on top of all these cases and making sure that we're a part of them, that we're sure that our voice is being heard. we can defend this rule appropriately.
Thank you for that. You know, Amber, you're a farm girl from a background, and you understand agriculture as well as anybody else. And you understand when you're dumping on the go and your wife is in the grain cart and you're in the combine, that coordinating is kind of important. So I'm maybe going to coordinate that and ask you to coordinate the questions a little bit. Do we have any questions in? Just reminding everybody, *9 if you're on the phone or using the chat feature. So Amber, do we have a question, or what's your first question?
We do have a question. Travis, the question came in that asks, has there been any recent legal efforts to challenge the Endangered Species Act regarding the delisting of the gray wolf?
I am not up to speed on where that litigation stands, or if there is litigation on the gray wolf. I would have to look at that and get back to you all. But AFBF is not currently engaged in litigation on that.
That sounds good, thank you. We don't have any other current questions in the Q&A, so if anybody has one, please submit those. Travis, I think Kevin raised a good point when he kind of talked about the implications of policy. But can you talk about any of the past cases? Are there any that you see that really kind of changed how we look at either policy or any, like, what do you think is one of the most recent, like, monumental cases that we've seen recently that's impacted agriculture?
So I think a big example of that is our success stopping the 2015 WOTUS rule in 27 and a half states. That rule was incredibly vague. It was a huge land grab, and it was very difficult for farmers and ranchers to figure out what on their land required an EPA permit. And stopping that in almost well over half the states was a huge win. I mean, I think every case that we pick it because we think it's going to have a significant impact on agriculture across the country. For instance, you mentioned ESA. We have, I don't know, about 4 or 5 ESA cases we've been involved with the past year alone. But one of them is defending some new ESA regulations that came out that make things a bit more clear and help the process of ESA consultations. There's a large NEPA rule that came out recently, which is a lot of things, including providing an exemption, categorical exclusion for NEPA reviews when a farmer needs an FSA loan. So, defending that, a lot of these things, they're very large issues that you might not notice immediately, but they have, over the long term, some pretty significant impacts on agriculture. And sometimes it will be more immediate. For instance, we had a case last year in the Supreme Court where we were able to overturn a 34-year precedent in what happens when the government takes a farmer's land. Does a farmer need to go through the state courts, where often it's a bit more of a tough process, the cards are stacked a bit more against the farmer, or can the farmer go straight to a federal court where the courts are a bit more adept to handle that kind of a constitutional issue? And it was a big one in the Supreme Court, and so that means that when the government does take your land in a way that's you deserve compensation, it makes it much easier for you to get compensation for that.
Very good, thank you.
Travis, curious, when we're doing rulemaking, many times we ask Farm Bureau members to submit comments and to do that for background, how it affects us and things like that. There's really not a process for that in the judicial side, but are those comments or any of that on the record? Does that have any impact on the judicial side of the analysis?
That's a great question. And it's much of the reason that you do comments are for the judicial side of things. Because so the way that rulemaking works is usually the agency will put out a proposal for a rule. That's when we look at it and we give our comments in on it. And before the agency issues the final rule, it needs to read those comments and respond to them. And if the agency doesn't respond to all the comments or doesn't give a good explanation for it, then that subjects the agency to litigation to overturn that final rule. So that would be a great example of when a comment, you put it in and it requires the agency to respond to you. And if they don't, or at least if they don't respond to you well enough, that can be an issue for the court to adjudicate. But it's also an interesting point that you raise about how you don't file comments in a court. Especially at the district court level, there isn't a whole lot of briefing from people that aren't a party to the case. more so when it gets to the Court of Appeals, the Supreme Court, I wouldn't call them a comment, but the amicus briefs are an opportunity for groups to let the court know, based on their own unique experience, what would be helpful for the court in deciding that issue. So in many ways, an amicus brief serves as a comment on a bit of a larger scale.
Thank you, that's helpful. Amber, any other questions that are coming in? While we're waiting for maybe time for one more question, Travis, if there was one thing you could tell a Minnesota Farm Bureau member or a Farm Bureau member or somebody involved in agriculture, as far as a misconception or what would be the biggest misconception of the judicial system as it pertains to agriculture?
That's a great question. What is the greatest misconception of the judicial system as it pertains to agriculture? I would say that courts anywhere in the country can impact you. And an example of that, I think, is the Dicamba case where, a court 2,000 miles away was able to cancel registrations for Dicamba all across the country. So essentially the impact and importance that a single court case can have, even no matter how remote it is. And what's crazy with the Ninth Circuit case on the Dicamba is that I want to say that Dicamba is registered in like 30 or 40 states. Only one of those states is in the Ninth Circuit. Ninth Circuit's a huge, huge state, and it barely even touches upon any jurisdiction that's in the Ninth Circuit, yet they're able to rule on a product that people that put substantial investments in very, very far away. So I'd say misconception is just the extent to which courts can have an impact no matter where they are, and the importance of staying involved and being on top of all these cases.
Thank you. Any other questions, Amber? If not, I'd like to just thank you, Travis, for your time today, but the entire AFBF legal team. I think a lot of our members don't maybe realize how much we're involved in the legal process as it deals with policy. The other thing I think we don't realize is many times when that information comes out, and it's very technical and lawyer speak, no doubt about that, but it's not just a page or two. And a lot of times, whether it's a Dicamba or you name the topic, we as the American Farm Bureau Board look to legal counsel and say, what do you think? And recognizing that was many, many pages of very complex topics and interconnected. So really appreciate all the time and energy you and the entire legal team spend helping us to be at the table. We understand in Farm Bureau, if you're not at the table, you'll be on the menu, and that's not necessarily just in Congress or just with administrations, it's in the courts as well. So any final comments, Travis, as we let you get back to work?
I really appreciate the opportunity to come speak to you all. I'm always here to do it. I love to talk to folks. And often we'll be looking for examples of cases and issues that farmers have when we're working on our briefs. And so we'll reach out to Minnesota Farm Bureau and other state farm bureaus. And if you ever hear that, and if you think you have an example that fits, please give it to us, because we're always looking to ways to help the courts understand issues that are being faced by farmers and ranchers. So thanks again, and I look forward to talking to you all soon.
Well, thank you, Travis. The other portion of today's Shop Talk, we've talked a lot about being behind the Bureau and who are the folks that make things work. And again, I want to thank the whole team to make this day work and this Shop Talk activity. But we're going to talk a little bit about operations today, and we're going to go to Dave Johnson to talk about, as Director of Operations, about that part of behind the Bureau. So Dave, please.
Hi, I'm Dave Johnson. I am the Director of Operations for the Minnesota Farm Bureau. I am responsible for accounting, finance, human resources, information technology, facilities, and fleet. The reason I enjoy working for the Farm Bureau is because it's like working for your family, and you want your family to succeed. Not only that, but every member of the organization has one common goal, and that is the betterment of agriculture. A little tidbit about me is that I lied to my wife. Let me start by saying I've been happily married for 25 years, and our birthdays are 2 days apart. I know that my wife's favorite cake is German chocolate cake. So when she asked me what my favorite cake was, it just happened to be German chocolate cake. I'm all about efficiencies. That way we only have to have one cake for our birthdays. So needless to say, I have been eating German chocolate cake for 25 plus years, and it's not my favorite cake. I'd like to introduce now, behind the bureau, Lori Wiegand.
Hi, my name is Lori Wiegand. I've worked for Farm Bureau for 16 years. My job title is accounting associate. My main thing for Farm Bureau is I work with membership and the membership system. My favorite thing about Minnesota Farm Bureau is our members, just a plain fact. A fun fact about me is in May, my son gave me my first granddaughter, and in November, my daughter will give me my first grandson. So.
Well, thank you, Dave and Lori. Both Dave and Lori, they're the numbers people. So my first question is for Dave. He mentioned that he's been happily married for 25 years. He never really gave us the number of how many total years he was married. Are those numbers similar, Dave, or are there two different numbers?
Same number.
Same number, good. And Lori, I really want to thank Lori. We just got done with this membership year, and as we're getting close to the end of membership year, we're asking her on a daily, if not a hourly, how are we doing, or are these members in, these members not in? I really appreciate the up-to-date information she gets out to all the counties, APDs, and everybody. Appreciate that. So thank you to the team of Behind the Bureau. Kind of make things run and pays the bills. So we thank you for that. Amber, what's next on the docket?
Well, I just have one quick update. Oh. There we go.
Can't hear you, Amber.
So we have one quick update on the legislative front. An issue that the Minnesota Farm Bureau has worked on for a very long time now is conformity to Section 179 of the Federal Tax Code. And that provision was included at the level of full conformity in the bonding bill that passed the legislature, the House of Representatives yesterday, and is on the floor of the Senate today. So we're happy to share some more information as those pieces become final. Keep an eye out for a special impact with more information on that. This provides some certainty to farmers and fixes an issue with like-kind exchange that happened in the 2019 legislative session. And so this provides a level of certainty for farmers in a time, year of 2020 has been a lot of uncertainty. And next week, Kevin, if you're President Papp, do you have anything to add before we do a nice preview of what we've got in store for next week?
Well, just a thank you for that update, Amber and Josie, on that. We will have a special impact if need be. We know we're all busy, but when we ask members to make those contacts, it's important. So whether it's from the barn or from the combine or the truck cab, those calls and emails are very important. But next week, we've done a banker, we've done a lawyer. I can't wait to hear what's next. What's next week?
Next week on Shop Talk, we will have a conversation with an ag journalist. We'll have Sarah Wyatt with AgriPulse come on, and she will give an overview of some of the things going on in her world, as well as some words of advice for all those out there, how we can be strong communicators on behalf of agriculture. We'll also have another segment of Behind the Bureau, so stay tuned for which team members you get to meet next week.
Well, thank you, Josie, and thank you, Amber, for helping run this call and everybody else around the table. Hope to see and hear from everybody next week on next edition of Shop Talk. But again, my one ask for everybody this week is to be safe out there, help look out for each other, and be careful on those rural roads. So this concludes this Thursday's edition of the Minnesota Farm Bureau Shop Talk. Thank you for joining us.